Okay, we'll go on the record now in let's see, Shaw versus Stiles. This is case number 2311441. If I could have both counsel put your appearances on, please. Mr. Hewitt, it looks like you're muted. Still muted.
There we go. Sorry, Your Honor. Charles Hewitt on behalf of Mr. Shaw.
Good afternoon, Your Honor. Nice to see you again, Mr. Hewitt.
Yeah, likewise, Mr. Carey.
You
made it back to your office. You made it back to your office before I did.
I set almost world record time from West Branch to Grayling, just so I wouldn't disappoint Judge Mertz. Anyway, Your Honor, I represent the defendants in this matter, the Stiles.
Okay, thank you. We're set for a status conference in this case. You guys tell me where we're at with this one.
Sure, Judge. We've had two mediations scheduled and had to adjourn both for various reasons. We currently have our next one set for, I think, July 19th. Bill, is that correct?
July 25th.
25th, I'm sorry. Got it close, yeah, in Grayling.
You were close. We had no problem picking a mediator. Scott Heston-Roscommon is going to handle mediation for us. I know the last adjournment was on me, and I apologize to everybody for that.
Okay, so do you want me to just go ahead and set this for another conference, maybe in August, following that mediation?
To me, that makes the most sense.
As likewise with me, Judge, I'm pretty confident we'll get this taken care of in mediation.
Okay, sounds good. So I'll send out notice of the date and time of that next hearing. If it settles in mediation and you guys are ready to file closing documents, just let my office know and we can take that date down so that you don't have to spend your time appearing.
Sounds good.
Sounds fine by me. Thank you.
Okay, anything else I can address for either of you while we're on the record today?
I'm good. Thank you, Judge.
Me too.
Okay, thank you. That's all for this file, and you're both free to disconnect at this time.
Thank you, Judge. Thank you, Jeff.
Hey, Bill. See you. Bye.
Okay, Ms. Bailey Quick, are you able to hear me okay?
I can. Good afternoon.
Good afternoon, thank you. Mr. Snuko, are you able to hear me okay?
Yes, I am.
Okay, we're on the record today in Black versus Black. This is case number 2311471. We have both counsel present here by Zoom video. Ms. Bailey Quick, I see you have your client with you. Mr. Snuko, is your client going to join in to this call? Do you know?
They were going to, Judge.
They were not going to?
They were going to join in, Judge.
Okay. The only other parties I see in the waiting room is under Carol and Paul Lowe. I don't think that's your client, is it?
That is, Judge.
Oh, it is. Okay. Okay, I'm bringing them in right now.
Thank you, Judge.
And while we're waiting for them to connect, I'm in receipt of a consent judgment of divorce. Ms. Bailey Quick, did you want to proceed with taking proofs and finalizing things today?
Yes, Your Honor.
Okay, and Mr. Snuko, is that how you wanted to proceed as well?
I did, Judge.
Okay.
That I'm not not sure if Miranda was able to get all the signatures on that, because I don't know what signatures are on it, so you want to ask her if she's got a different one that she's emailed with all the signatures.
Okay, so Ms. Bailey Quick, I'm gonna start by placing your client under oath, and I'll have you take proofs from him. So, Mr. Black, you can raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand, and Ms. Bailey Quick, please proceed when you're ready.
Thank you. Mr. Black, would you please state your name and spell your last name for the record?
Jeffrey Joseph Black, Black.
Thank you. And we participated in the mediation process last Friday, and you and Ms. Black came to a full resolution. Is that correct?
Yes,
Right? And at the time you filed your complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
yes,
And at that time, had you lived in Crawford County for at least 10 days before filing your complaint for divorce?
yes,
Were you and Ms. Black legally married in Warren, Macomb County, Michigan on June 23rd, 1993 by a person authorized to perform marriages?
yes,
And by your information and belief, is Ms. Black currently pregnant? Okay. You and Ms. Black do not have any minor children born of the marriage, either natural or adopted, is that correct?
yes,
And you and Ms. Black acquired certain property and debt that this judgment of divorce equitably divides. Is that correct?
yes,
Okay. At the time you filed your complaint for divorce, you had alleged that there had been a breakdown of the marital relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at that time?
yes,
And does that remain true today?
yes,
Okay. You've had an opportunity to review the judgment of divorce that has been sent to the court, and you've signed that judgment electronically. You agree with that?
yes,
Okay, and do you agree that that judgment comports with the mediation agreement?
yes,
Okay. In the judgment of divorce, you've been awarded the real property located at 1676 Chippewa Lane. And that in exchange for that and full settlement, you are going to pay Ms. Black $80,000 within the next 6 months or before December 1st for her full settlement in this divorce action. You agree with that?
yes,
Okay, and if you are unable to pay $80,000 on or before December 1st, you agree to list the property for sale. And at the time of sale of that property, Ms. Black would receive the first $80,000 from the sale, and you would receive anything after that. You understand those terms?
yes,
And Ms. Black has agreed to sign contemporaneous with being presented with that quitclaim deed. She has agreed to sign that, and I would hold that until which time you would pay her the $80,000. And if you're unable to pay that on or before December 1st, I would then destroy that deed by December 1st. You understand that?
yes,
If you were able to pay the $80,000 on or before December 1st, then at the time of payment of the $80,000, they would sign a satisfaction of judgment, and that quitclaim deed would be able to be recorded. You understand those terms?
yes,
Okay. Also in the judgment, it provides that you will keep all of the personal property, clothing, jewelry, separate property, and other assets currently in your possession, other than Miss Black's mother's fur coat, which the two of you will coordinate how to return that. You agree with working with her to get that fur coat back to her?
yes,
Okay. And as part of that $80,000 payment, you will continue to retain possession of the 2019 F-150, the 2020 Ford Escape, the 2017 four-wheeler, and the 2015 pontoon boat. And as part of that, you'll remove Miss Black's name from the liability on the pontoon boat. And you'll do that within the next 6 months. You agree to those terms?
yes,
Okay. Both of you have asserted that you have no pensions, retirements, or IRA accounts. Is that true?
yes,
Okay. And also as part of the agreement is that each of you would keep your own bank accounts and you'll remove your name from the joint bank account at North Central Credit Union. You'll cooperate and do that as soon as possible following entry of the judgment. Do you
Yeah.
agree with that? Okay. And you'll be responsible for your own debts, and Miss Black will be responsible for her own debts, including your own attorney's fees. You agree with that?
Yeah.
And in consideration of that $80,000, that also contemplated any type of spousal support or alimony. And you agree that in that $80,000, it includes any consideration for spousal support, and for spousal support, there is not going to be any additional payments, and spousal support is forever barred after entry of the judgment of divorce. You understand that?
Yes.
It's non-modifiable, and you can't come back and ask the court to change that after entry. You understand?
Yes.
I have no further questions for my client, Your Honor.
Mr. Sunuko, did you have any questions for Mr. Black?
Not for Mr. Black, no, Judge.
Okay, did you want to take some testimony from your client?
Just a few questions, Judge.
Okay, I'm just gonna need, Ms. Black, for you to, unmute, please. Thank you. And ma'am, are you Julie Black?
Yes,
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes, I do.
Thank you. You can lower your hand and proceed when you're ready, Mr. Sunuko.
Thank you, Judge. Ms. Black, we participated in mediation last Friday, is that correct?
Yes,
And we settled the issues that were involved in this divorce matter, is that correct?
yes, we did.
And we put it into, the mediator put it into a written form, is that correct?
Correct.
And we signed that document.
Yes, we did.
Okay, and then we emailed you a consent judgment of divorce.
As far as I know, yes.
Yes, you read that, correct, today?
Yes,
Okay, and you're in agreement with the divorce terms as put on the record and as contained in that judgment, correct?
yes,
Okay, and you understand that we could have gone to trial and done better or worse or the same, correct?
yes, I do.
But you wanted to settle this matter and the judgment accurately reflects our settlement.
Yes, I did.
Okay, and you're satisfied with my representation.
Yes, I am.
Okay, very well, Judge. I'm all set.
Thank you. Ms. Bailey Quick, did you have any questions for Ms. Black?
Just a couple, Your Honor.
Okay.
Thank you. Ma'am, you are not currently pregnant, is that correct?
No,
And you did electronically sign that consent judgment earlier today, is that correct?
correct.
All right. I don't have any further questions, Your Honor.
Okay, thank you. The only question I have, counsel, is the copy that I received does not have electronic or actual signatures on it. How do you guys want? Do you want me to sign this copy, or do you want to present a different copy to the court for signing?
I just emailed, I just received the final signature shortly before the court proceeding, and I emailed that to Ms. Medler. That has all of the parties' signatures electronically on it now.
Okay, so you want me to sign that one?
Yes, if you would mind, Judge.
Okay, all right. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. I've reviewed the proposed judgment, and it does comport with the parties' testimony here on the record and contains all the provisions required by statute. So I'll sign that judgment, the final copy, once that's presented. Anything else I can address for your side today, Ms. Bailey Quick?
No, Your Honor, thank you so much.
All right, Mr. Sunuko, anything from your side?
Nothing further, Judge. Thank you very much.
Okay, thank you. Parties on this file are free to disconnect at this time.
Thank you,
Thank you,
Judge.
Your Honor.
Okay, let's see. Mr. Jaskowski, can you tell me which case you're appearing on today?
Yes, Your Honor. I was just here for the Reedy matter. I didn't see an order on the file substituting in Mr. Menke's, so I just wanted to make sure that we were all good there.
Okay. All right, let's go on the record in that file then. This is Bodet versus Reedy, case number 2311562. And if I can just have all counsel put your appearances on the record, starting with plaintiffs, please.
Thank you, Your Honor. Troy Stewart here on behalf of the plaintiffs in this matter.
Judge, Mike Menkes, and I'm a little confused now too, because for the first time I just saw Mr. Friel's appearance. But I substituted in for Mr. Jaskowski for David Reedy. And it was determined that William Reedy is not an insured under the policy that I'm providing the defense on. And thus the carrier then contacted Mr. Friel's office so as to represent and substitute in for William Reedy, but I see that now Mr. Friel has filed an appearance as co-counsel on behalf of both defendants. But it's my position that I'm supposed to be representing defendant Reedy, David Reedy only, and then John Friel is appearing on behalf of William. But that's just something we're going to have to sort out.
Okay, Mr. Friel.
Yes, I am in fact, excuse me, I am in fact John Friel on behalf of the defendant. I understood I was to appear and defend, but not be involved in the countersuit. So that's why I kind of worded it that way, but I agree that we'll be able to work that out very easily. Whatever it is what we'll do.
Okay. All right. Do we have either Alan or Sandy Bodet here? Is that any of you folks, or William or David Reedy? Who are you, sir? William. William, if you want to come forward, please. I mean, you don't have to. You're a party. You have a right to be at the table, but it's up to you.
No, I'm going to sit back here, be silent.
Okay.
Thank you.
All right. So just so council's aware, William Reedy is present here in the courtroom, but he's indicated he's wants counsel to speak for you. Fair statement.
Yeah, it's fine.
Okay. All right. So this is set for a status conference today. It was set for a motion to withdraw, I think, on behalf of Mr. Jaskowski's firm. It sounds like that's already been taken care of in terms of substitutions of counsel.
Your Honor, that's on behalf of the plaintiff's counsel that we filed that motion to withdraw.
Okay, all right. And I guess I should note for the record that neither of the Bodets who you represent, correct?
Correct.
Okay, neither of them have appeared here in court today, nor are they present by Zoom video. Is there anything you wanted to say in support of your motion to withdraw then, Mr. Stewart?
Just for the record, Your Honor, they were sent a copy of the motion and the notice of hearing and everything. I don't have a whole lot to add to the motion. You know, we did try to work with them. I communicated with them back on April 23rd about our intent to file a motion to withdraw. We weren't unfortunately able to work anything out. We've also kind of had a breakdown in the communications. We still haven't received any payments since we filed the motion and are owed more than what is reflected in the motion. So for all those reasons, Your Honor, we would request that the court grant the motion and allow us to withdraw, but also give the Bodets time to find some new counsel.
Okay. Does any defense counsel take any position on the motion?
Judge, Mike Menkes on behalf of David Reedy. The only position I take is this. Of course, I don't object to the motion. I anticipate the court will grant it. But based upon past experience, so as to avoid this case languishing, what I would like included in the order is that the plaintiffs be given 30 days from the date the order is entered to either retain new counsel with an appearance being filed, or they file their own appearance in pro per. And in default of that, then defendants will be able to file a motion for dismissal of the case. so we can keep this moving along.
Okay, thank you. Any other input from either of the other defense counsel? Although Mr. Jaskowski, I think you guys have been substituted out. You're free to remain on the call, however.
Yes, Your Honor. Thank you.
Okay, Mr. Friel?
I don't have anything to add except that we would ask that the order not impair counter plaintiff's ability to gain the relief that they seek as well.
Okay, so the court will grant the motion. I reviewed, Mr. Stewart, your motion to withdraw. The court finds there are adequate grounds, so the court will grant the motion. Mr. Stewart, I'll ask, I think 30 days is a fair amount of time, excuse me, given that the motion to withdraw was served back on May 10th, so almost a month ago. So that really puts plaintiffs on notice for almost 2 months. I think that's an adequate amount of time for them to obtain counsel. So, Mr. Stewart, if your order can specify that plaintiffs will have 30 days from the date of today's order to obtain new counsel. Mr. Menkes, I don't want to put anything in there about what kind of relief the court may or may not grant, depending on what happens with that, but certainly you'd be well within your rights to the extent that that's not complied with to request the relief that you're asking for. But I think that would have to be the subject of further hearing.
No, I agree, and I understand that. I just would like there's some language put in that in the event no appearance is filed, then the defendants may file a motion asking for that relief. Now, there's no prejudgment. It's just that at the conclusion of 30 days, we don't have an appearance from anybody or improper, then we can just go ahead and file our motion, and it will have to be determined by the court at that point whether the case will be dismissed.
Okay, I think, Mr. Stewart, the language I think that would be appropriate is plaintiffs have 30 days to obtain new counsel. The case will proceed regardless after that time, whether they have counsel or not. And I think that'll address your concern, Mr. Menkes.
Yeah, that's good. Thanks, Judge.
And frankly, it'd be my intention, whether that's in the order or not, to go forward with the case at that point. So, but I don't have a problem having that language in the order. So, Mr. Stewart, can you submit that either under the 7-day rule or with the stipulation as to form?
Yeah, just to clarify, so I can put that they'll have 30 days from the date of the order to obtain new counsel, and the case will, or if not, the case will still proceed. I guess I just want to phrase it to kind of appease everybody here.
Yeah, I think that's accurate. That comports with what I'm indicating.
Okay. I will, I will submit that order, Your Honor. And just for the record too, I had a note of this. We did send out our initial discovery disclosures for this case back in February. I believe they were probably sent to Mr. Jakowski's office, but just so the other counsel know that we did take that step before it kind of got bogged down.
I have them. Yep, I'm in receipt.
Okay, and then Mr. Menkes and Mr. Friel, I guess my thought would be to set this for another status conference next month. If the plaintiffs have obtained new counsel, then we'll be able to talk with everybody involved. If not, then we'll decide how to go from there. Do either of you guys have an objection to that?
No objection.
That sounds good.
Okay. All right. Anything else I can address for any of the parties while we're on the record here today?
Not from my perspective, Your Honor. Thank you.
I think we're all set.
Yep.
Okay. All right. Thank you. All parties are free to disconnect on this file.
Thank
Thank
you.
you.
Thank you, Your Honor.
Next hearing set for 2:15, so we'll take a short recess until that time.
Hello,
Hi there. Can you tell me your name, please?
Deanne Sweers.
Okay. And have you had any contact with Mr. Sweers at all?
Yes.
Do you know if he was planning on appearing today? Because I don't see him in the Zoom waiting room.
He is not planning to appear. I'm going to speak on behalf of both of us.
Okay, all right. For the record, this is Sweers versus Sweers, case number 2411623. We had the plaintiff, Ms. Sweers, present today by Zoom video. Mr. Sweers is not. Ms. Sweers, I'm in receipt of a proposed judgment of divorce. It looks like it's been signed by both of you. Did you want to proceed with entering that judgment here today?
Yes, please.
Okay, can you raise your right hand, please?
Yes,
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. And Ms. Sweers, I'm going to ask you a series of questions. These are the questions I'm required to ask to establish the grounds for divorce under Michigan law.
Okay.
My first question is, you signed a complaint for divorce in this case. And at the time that you signed that complaint, have you been a resident of the state of Michigan for at least 180 days?
Have I resided in, did you say?
Right, yep.
Yes.
Okay. Had you been a resident of Crawford County for at least 10 days?
Yes.
In that complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remains no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes, that's correct.
Does that remain true today?
Yes, it does.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, we have no minors right now. They're all adults.
Thank you. Are you currently pregnant?
No.
Okay. And under the judgment of divorce that we're going to be entering today, you are not going to be receiving any alimony or spousal support. Is that correct?
That's correct.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
I do understand that.
Okay. And you and Mr. Sweers have entered into a property settlement agreement that's in writing that you both have signed, and it's attached to this judgment of divorce. And that property settlement agreement, does that represent the division of all of the assets and debts of the marriage?
It does.
Are there any issues regarding that that remain for the court to decide?
There are not any issues.
And are you asking the court to grant the divorce based on that property settlement agreement?
Yes, we are.
And do you think that that is a fair and equitable division of all the assets and debts of the marriage?
Yes, I do.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of Ms. Sweers. I have reviewed the proposed judgment as well as the property settlement agreement. The court finds it to be generally equitable and to contain all the provisions required by statute. I also note that while Mr. Sweers is not present today, it does appear that his signature is on both the proposed judgment as well as the property settlement agreement. So the court will grant the divorce, and I've signed that judgment. Are you asking to have your last name changed?
I am not asking to have my last name changed.
Okay. All right. Ms. Sweers, do you have any questions?
I do not have any questions.
Okay, that is all for this hearing today, and you are free to disconnect at this time.
Okay, thank you, Judge Mertz.
Thank you.
Mhm.
Steve, he does like you.
That's where I started. My home base. All right, ma'am, can you unmute yourself, please?
Yep.
Thank you. Are you Kimberly Robertson?
Yes.
Okay. And it looks like Mr. Robertson is signing in, so if you could just hold on for 1 minute. All right, Mr. Robertson, can you unmute?
Okay, I think I got it.
Yes, you do. Are you Vincent Robertson?
Yes, sir, I am.
Okay. All right, we're on the record now in Robertson versus Robertson. This is case number 2411627. The record should reflect both parties are present today by Zoom video. I have this set for a final hearing to finalize a divorce in this case. Ms. Robertson, is that how you wanted to proceed?
Yes.
And Mr. Robertson, is that how you wanted to proceed as well?
Yes, sir.
Okay, can you both raise your right hands, please? Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, sir.
Thank you. You can lower your hands.
Yes.
I'm going to be asking you both a series of questions. The questions that I'm going to be asking are the questions I'm required to ask to establish the grounds for divorce under Michigan law. My questions are going to start with you, Ms. Robertson. You filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for 180 days?
Yes.
Had you been a resident of Crawford County for 10 days?
Yes.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that
That's
true
correct.
when you signed that complaint?
Yes, that's true.
Does that remain true today?
Yes.
Are there any children who are under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
You understand that under this divorce judgment, you would not be receiving any alimony or spousal support?
Yes.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
All right. You've already divided up any personal property between the two of you, is that correct?
Yes.
And do you own any real estate or real property together?
No.
Okay, and are there any matters relating to the division of the assets or debts of the marriage that remain for the court to decide?
No.
Thank you. Mr. Robertson, have you heard all the questions that I asked Ms. Robertson?
Yes, sir, I have.
Have you heard all of her answers?
Yes, sir.
Do you have any reason to believe that any of the answers she gave are untrue?
No, sir, I don't.
And you understand that you also will not be receiving any alimony or spousal support?
Yes, sir.
And you understand that you would be waiving that forever and could not come back later and ask the court for that?
Yes, sir.
And do you agree that there are no remaining issues for the court to decide regarding the division of any marital assets or debts?
No, there are not.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. I've reviewed the proposed judgment and finds that it contains all the provisions required by statute. So I signed that judgment of divorce. Ms. Robertson, you're asking to have your last name changed, is that correct?
Yes.
So from today forward, because the divorce will be final, your name will be legally changed, so you'll need to change your identification and other documents, okay?
Yes. Thank
Do you
you.
have any questions at all?
No, thank you.
Mr. Robertson, did you have any questions?
No, sir, I do not.
Okay, thank you. That concludes this hearing today, and both parties are free to disconnect at this time.
Thank you.
Thank you, sir.
Not that there's a shortage of those. I did go up front, I mean, did not see, because usually the attorney's here, I don't see her, I don't see her, I don't see him. He showed up here at the last hearing. The guy did, yes. And then it got adjourned to today's date, because that was one where she apparently was on Zoom. I didn't have the notice of hearing, they did, she was on Zoom, he showed up in person, I didn't have the notice, and then it got set for today.
Morning, Your Honor.
Okay, is that Mr. Matisse?
Yes, Your Honor.
Okay, are you appearing on the Michael Olsen versus Ron Gildner case?
Yes, I am, Your Honor.
Okay. All right, and this was set for a show cause here regarding a debtor's examination, is that right?
That is correct, Your Honor.
And the debtor is Mr. Gildner?
Correct, Your Honor.
Have you had any contacts with him?
No, we have not, Your Honor.
Okay.
We've been unable to locate him for whatever reasons we need to get a hold of him.
And I did give their attorney's office his phone number.
Okay. All right, we'll go on the record. This is Olsen versus Gildner, case number 2311313. We have Mr. Matisse here present on behalf of the plaintiff. As I just indicated, this matter was set for hearing today on show cause. Mr. Gildner failed to appear back on April 4th at 2:30. So we set this hearing today. This was set for 3:15. It's now 3:20. Mr. Gildner is not present here in the courtroom. He's not present by Zoom video, and my court officer is just checking the lobby. So, Mr. Matisse, if you could just hold on for 1 second.
Of course, Your Honor.
All right, the court officers checked the lobby. There is nobody present. So, Mr. Matisse, how did you want to proceed?
We would ask that this court find him in civil contempt, Your Honor.
All right, the court notes that Mr. Gildner was properly served with notice of the date and time of today's hearing. That service was made, let's see. Back on was filed on May 20th. Service was accomplished prior to that on May 9th. So the court finds it would be appropriate to find Mr. Gildner in contempt at this time. There's a couple of ways that we can go, Mr. Matisse. I mean, the court can issue a bench warrant. Do you have a method that you prefer to try and get a hold of Mr. Gildner?
Bench warrant would be work well in this case, Your Honor.
Okay, what is the amount of the debt that's owed?
One moment, Your Honor. It is a substantial amount. I do know that. Let me pull this information up.
Okay. Okay, I think I have it, 29,000, at least as of April of last year.
I think it was actually more, but that could be it, Your Honor.
Okay. All right, so the court will issue a bench warrant for Mr. Gildner based on his failure to appear both at the April hearing and today. And then we'll go forward from there. Is there anything else I can address for your side today, Mr. Matisse?
Nothing else, Your Honor.
Okay, the court will prepare that bench warrant. You'll be provided with a copy of that by the court staff, and then it'll be filed and entered into lien, and then we'll proceed further once Mr. Gildner is brought before the court.
Thank you, Your Honor.
Okay, that's all for today. You are free to disconnect at this time.
Thank you, sir.
And that also concludes the court's afternoon docket.